Okay, today's Thursday, the 15th of May.
Yep.
And we're here to get a decision from the judges of the High Court in regard to the indictment against Justice Adams of the Supreme Court. So far they've been denying John trial by jury all the way along the line, and it's just been a railroading experience because they maintain that judges are above the law and they cannot be prosecuted even though they do the worst crime. And the worst crime that they commit is denying us our inalienable right to trial by jury. Without trial by jury, we haven't got democracy, we haven't got truth, we haven't got justice, we've got nothing. So this is what today's all about, to get the formal dismissing of the charge against Adams, which is the nail in the coffin as far as the judiciary is concerned, because they sealed their fate. They are making it quite determinedly known that they disregard the will of the people, and they are all powerful, and so this is just another instance on the way to us achieving what we want to achieve, which is to throw out all the criminals and traitors. So we'll see how we go today. Okay, we're here at Magna Carta Monument, and we'll go in so John can read the judgment. Okay, John, read that judgment.
Read that judgment, yes. The respondent to this application for special leave of appeal is a judge of the Supreme Court of New South Wales, Justice Adams J. In 2006, Adams J. found the applicant guilty of contempt of court and ordered that he be sentenced to 14 days imprisonment. No appeal was brought against His Honour's orders. Number 2. However, by summons filed in the Supreme Court on the 27th of February 2007, the applicant alleged that Adams J. had committed an offence under Section 43 of the Imperial Acts Application Acts 1969, New South Wales, and sought a jury sentence of 5 years imprisonment. The alleged offence was identified in Adam J.'s refusal to allow the charge of contempt of trial by jury. Number 3, on the 14th of May 2007, Johnson J. ordered that the summons be struck out. In so ordering, His Honour held that there was no right to a trial by jury on the charge of contempt and that no offence in law was disclosed in the summons. The matters alleged in the summons involved the exercise of Adams J. of his function in hearing the judicial proceedings. Number 4. Leave of appeal to the Court of Appeal was refused by Mason P. and Hoban J. on the 19th of October 2007. Their Honours affirmed the correctness of the reasoning and conclusions of Johnson J. and expressed the view that any appeal would be hopeless. Number 5. The application for special leave to appeal does not advance any question of law that would justify the intervention of this court. There was no prospect of success on any appeal to this court. Special leave is refused. Number 6. Pursuant to Rule 41.10.5, we direct the registrar to draw up, sign and seal an order dismissing the application for special leave. Signed, WMC Gummow, G-U-M-M-O-W, and S.M. Kiefel, K-I-E-F-E-L.
15th of May.
15th of May 2008.
Okay, so we went to the High Court. What happened when we went in there? We sat down and the judges came in, and what happened?
When my name got called out, I stood up and said, I'm here, and I started to walk towards the bench. I was stopped by the sheriffs and not allowed to proceed any further. And then they all left the court.
Yeah,
wouldn't let me say a word.
No.
So that is justice for you.
So there was actually an application for special leave to appeal Ordinarily, there's a 20-minute oral presentation. You were not allowed that. That was all done in your absence without you saying a
That's right.
word.
Everything.
We went down to the registry and demanded a copy of that judgment, and they said no, they would not provide any transcript. That it was
Well,
all.
there is no transcript, they said,
That's right. Okay.
of a hearing, and
No.
wouldn't allow me to say anything in
No.
to do with the case.
So in other words,
So,
it was just
my-
a rubber stamping,
Yes.
railroading, out the door. Judges are not to be brought before a jury.
No, just
Okay.
this was judgment that they've written out weeks ahead of time, and it was just rubber stamp.
Okay.
All it was.
Show us that T-shirt you got put in jail for 14 days for.
There you go. Trial by jury is democracy.
Okay. And the judges, they don't like that because
No.
it takes away their power.
That's right.
Okay.
And
All right.
even in this year, they admit that arbitrarily I got put away without a jury, without my right to appeal, without my anything.
Okay.
How can you appeal when you're in jail?
The fight's not over.
When I was down at the registry office, I asked a very logical question, I thought. I says, how is it possible that a decision can be made upon a legitimate case before the court without any say or defence by the person involved that the decision is being made about? And the spokeswoman was lost for words.
She was very...
It's totally unfair, unjust and undemocratic.
And against all the rules of natural justice.
That's right.
That's it.
Totally, there was none.
Okay, John, why are we here at Parliament House?
Why? To fight for our rights.
Who are we going to see?
We're going to try and see, what's his name? Clare.
Jason Clare.
Jason Clare, my federal member for Blaxland, hoping that he might see the Attorney General and maybe do something.
Want to ask for an inquiry?
The which?
Do you want to ask for an inquiry or anything?
Well, I'll try it like true, but we'll see
Yeah.
if we can get to see him first.
Yeah.
Once we see him, then we can put the proposition to him what we're going to do.
Okay, doke.